Okay. So in relation to a company, how can it be shown that a company had a criminal intent, which is major questions, the major question that was asked in the 1840s? How is it possible that a company can be said to have a criminal intent? This question was answered long ago in the English case of DPP versus Kent and Sussex Contractors Limited. And in the case, the company was charged with doing an act with intent to deceive and making a statement which it knew to be false. The divisional court held that the company could be liable and therefore have the necessary intent to deceive. The court will, however, only convict if all the essential elements of the offenses are present. That was the case then. Because of the nature of the company, it is not all offenses that it can be indicted for. There are some offenses that a company cannot be indicted for. We looked at the case of Abacha versus AG Federation, wherein on the legal personality of a company and whether agents of its subscribers or trustees can be held liable. The court held that by virtue of Section 37 of the Companies and Allied Matters Act 1990, an incorporated company is a creation of the law, clothed with independent legal personality. From the moment of its incorporation, it has distinct and separate personality from those that labored to give birth to it. We'll discuss more on that in our chapter 2. But we also looked at the historical development of corporate liability. And in the early 70s, corporate criminal liability faced at least 4 obstacles because the corporate form was less pervasive as at that time. The public may also have been relatively indifferent to corporation crimes. The first obstacle was attributing acts to a juristic fiction, that is the corporation. And the second obstacle which was faced was the legal thinkers. It was that the legal thinkers did not believe corporation could possess the moral blameworthiness necessary to commit crime of intent. One important purpose of the criminal law is punishing the blameworthy. So imputing an agent's intention to the corporation seems inconsistent with its purpose. Another obstacle was that the ultra-virus doctrine, under which courts would not hold corporations accountable for acts such as crime that were not provided for in their charters. And finally, the fourth obstacle that was faced with the doctrine of corporate criminal liability was the court's literal understanding of criminal procedure. For example, judges required the accused to be brought physically before the court. How would that be possible for a corporation? So the first step towards corporate criminal liability were taken in common law jurisdiction. Common law sources haven't been among the first to talk about ethics in corporation and deterrent effects of sanctions on company behavior. Both in the UK and in the United States, the Industrial Revolution and attendant expansion of the railroads led courts to apply civil law doctrines of vicarious liability in criminal cases. Courts in both the England and the United States first imposed corporate criminal liability in cases involving non-feasance of quasi-public corporations, such as in quasi-public corporations and also municipalities, that resulted in public nuisance. So that was one of the first cases that the courts in the UK and in the US addressed, were cases of public nuisance by quasi-public corporations and municipalities. Also, in the early 80s, or in the early 1800s, courts began holding commercial corporations criminally liable for the sort of public nuisance that were previously inflicted by quasi-public corporation. These cases of corporate criminal liability did not fall foul of the two obstacles that we have mentioned earlier. First, no individual agent of the corporation was responsible for the corporation omission. And secondly, there was no imputation of guilt from agent to principal, because only the corporation was under a duty to perform the specific acts in question. So these were the questions that arose as of then when it comes to criminal corporate liability. They were of the view that it is not the agent that committed the offense or the omission. And secondly is that the imputation of guilt, the court was not able to impute guilt on on the on the corporation through its agents. Okay, so we looked at the case of the Queen versus Great North of England Railway Co., where Lord Ll.M held that corporation could be criminally liable for misfeasance, and American courts soon began making similar rulings, such as in the case of State versus Morris Railroad Co. So the advancement in the end stimulated courts to outspread corporate criminal liability to all crimes not requiring intent. So, in order to hold corporations liable for misfeasance, courts imputed agents' conduct to corporation, and such imputation would have been theoretically troublesome without the doctrine of respondent superior, also known as the doctrine of vicarious liability or master servant rule. However, the doctrine was established as common law by the time court decided the first corporate misfeasance case in the mid 1800s. We spoke more on the history of corporate criminal liability, but in order for us not to waste time, we'll go to the theories of corporate liability. So one of the theory is the agency theory. And what this theory means is that the corporation is liable for the act and intent of its employees. Vicarious liability is based on, it's also known as vicarious liability. Vicarious liability is based on the principle of respondent superior, which means let the master answer. It is a general rule of thought where the employer can be held liable for all the acts of the employees done during the course of employment. Vicarious liability is commonly employed in the United States, and in other jurisdictions, the theory is established in relation to strict liability and hybrid offenses, but not mens rea offenses. This theory is based on the fact that criminal violation entails two elements, which is actus reus and mens rea, that is the act and the intent. Since a corporation is an incorporeal legal entity, the only way to impute intent is by considering the state of mind of the employees. Whoever has the intention of the company is part of the corporation, and therefore the intention of the employee is also the intention of the corporation. So to determine whether the corporation will be held vicariously liable for the acts of the employees, the employee must first be acting within the scope of his employment. In the case of New York Central Railroad versus United States, the corporation was convicted of violating the Elkins Act, where a general and an assistant traffic manager paid rebates for shipment of sugar. The agents were operating within the real authority system because they were allowed to set freight rates. Therefore, they acted within the scope of the authority and the organization put on them. So the company was held liable. In the case of the United States versus Perfect Powder Puff Company, it was held that independent contractors must operate for the corporation's benefit and thus subject it to criminal liability. The agent acted within the scope of actual authority because they were authorized to set up freight rates. So this case is also trying to say that not only the employees of the company, but even independent contractors, the company too can be held liable for the action of independent contractors if they act within the authority that was given to them. So even non-employees' conduct can be attributed to be as the corporation action. It was further held that it was further held in the case of United States versus Perfect Powder Puff that independent contractors might act for the benefit of the corporation, thereby exposing it to criminal liability. Secondly, the employee must be acting at least in part for the benefit of the company, even if that employee is also going to benefit from that criminal um act or omission. The corporation too must benefit from it for the corporation to be held vicariously liable for it, for the action. So in the case of, okay, the third factor, we looked at the case of the United States versus Bainbridge Management. And the third factor is that the act and the intent must also be imputed in the corporation. It must be imputed to the corporation. We looked at identification theory, which is also known as the directing mind and will theory or organic theory, and it represents one of the principal doctrines through which corporate criminal liability is attributed to a company. The theory proceeds on the premise that a corporation, being a juristic and a non-natural person, must act through human agents. Within this framework, the acts and mental states of certain key individuals, typically those at the highest level of decision making are identified with the company itself. Under this theory, a corporation is regarded as a body composed of various organs, where directors and senior managers constitute the brain of the company. So this theory is just saying that the brains of the company will be the one, will be held liable for any corporate criminal act that was done by the corporation. The principle is that if a person who can be considered the directing mind and the will of the company commits a criminal act in the course of the company's business, then the company itself is deemed to have committed that offense. In the case of Tesco Supermarket Limited versus Natras, Lord Reid held that a living person has a mind which can have knowledge or intention or be negligent and has hands to carry out his action. That is a corporation is a living person that has a mind, and that this corporation acts through, that is the mind of the corporation are the superior officers of the company, and so they can be held liable for the corporate crime committed by that corporation. And same was reaffirmed in the case of MMA versus National Marine Authority, where the court likened a company to a human body, noting that it has a brain and nerve center which directs its action, as well as hands that perform those actions. The court also held that some of the people in it were mere servants and agents who are nothing more than the hands to do the work. Others are directors and managers who represent the directing mind and will of the company and are treated by the law as such. So, Lord, the origin of the theory can be traced to Viscount Eldon's statement in Leonard's Carrying Company Limited versus Asiatic Petroleum Company Limited, where the House of Lords recognized that a corporation may be equated with individuals who are its directing mind and will. This could include directors, managing directors, or individuals who have been delegated authority to act independently of the board. So this theory has been criticized. Basically, this theory is just saying that the directing minds of the company can be held liable for the corporate crimes committed by this company. But it has been criticized by several jurists. It has been criticized for overly restricting corporate criminal liability to only the conduct of senior executives or directors. Some say that some of the jurists have criticized it on the ground that some of these corporate crimes were committed by lower officers of the company. And so why should the senior executive be held liable when some of these crimes are even committed by these young ones in the company, the young officers of the company? So they state that in reality, many corporate crimes are committed at the level of middle or lower management, particularly in large decentralized organizations. So the theory fails to capture these situations, thereby insinuating insulating the corporation from liability for decisions made outside the boardroom. Secondly, some scholars argue that the theory is too broad and simplistic. It automatically attributes liability to corporation based on the actions of designated individuals, even where preventive measures were taken by the company to avoid such illegal acts. Just like the example that I made earlier, where there are times where the senior officers put in measures to prevent the commission of crime by young officers. So the theory only limits it to making them liable, even when they put up prevention measures. They've tried their best to stop some of these criminal acts. It has also been noted that the theory also struggles to appropriately transpose the elements of mens rea and actus reus, which are inherently individualistic, onto a collective legal entity like a corporation. So the Canadian courts, for instance, have taken a more progressive stance by locating the directing mind and the will as lower levels within the corporate structure. So the Canadian court has taken its own step to ensure that, okay, even the directing minds at the lower level of a corporation will be held liable for any corporate crime. But that has not been effected with the English court. We have another theory, which is the aggregation theory, also known as the aggregation model, organization theory, or doctrine of collective knowledge. And it was developed on the account to account for the fragmented nature of corporate decision making. The aggregation theory seeks to overcome the limitation of attributing liability only when a single individual or the directing mind satisfies the culpability criterion. Instead, the theory actually proposes that the conduct and knowledge of two or more individuals, whether acting directly for the corporation or from whom the corporation is vicariously liable, it may all be aggregated to form a complete basis for establishing corporate liability. Technically, it's so simple. What it means is the fact that only um, one of the officers or one of the directing mind is not completely aware of the crime, is not necessary. If one or two people are aware of that crime, one or two people are partially or completely aware of that crime, aggregately, they can all be held liable for it. So this means that even if no one person possesses all the requisite elements, such as intent or knowledge, for an offense, the collective contribution of their individual parts may be pieced together into a coherent criminal whole. In the case of United States versus Bank of New England, in a charge of willfully failing to file reports relating to currency transaction exceeding a certain statutory amount, the direction of the jury was that the bank knowledge is the totality of what all the employees know within the scope of their authority. So if employee A knows one facet of of the currency reporting requirements, and B knows another, and C knows the third part of it, then the bank knows them all as a whole, and the bank will be held liable. So under this model, corporate liability is not contingent upon any single employee or executive reaching the threshold of culpability. Instead, the knowledge of various employees may be aggregated, thereby obviating the need of an individual to satisfy the entire mens rea requirement on his or her own. So we know that mens rea and actus reus are elements that must be known, required elements must be known to establish criminal liability. But in this instance, they are saying even if one person or one employee, one directing mind of the company, it does not have the complete requirement, that is actus reus and mens rea. The fact that other employees too, maybe other employee has actus reus and the other one has mens rea, they can all be put together aggregately for the crime. So one of the advantages of this model is that it mirrors the reality of modern corporation, where no single executive often make all decisions, and knowledge is divided among different departments and level of management. Another advantage is also that the aggregate knowledge av- the aggregate knowledge avoids the strict requirement that an offense must be committed by a single person who possesses complete knowledge or intent. Instead, it allows for a more flexible analysis of corporate wrongdoings. And finally, this approach is particularly effective in cases involving negligence, where a collective failure to exercise reasonable care may be evident even though no single individual is entirely at fault. So it was also criticized by different scholars, and one of the criticism is that one of the criticism is its rejection in common law. Courts in jurisdictions like the UK and other Commonwealth nations have generally rejected the aggregation model, preferring to maintain the more rigid identification of vicarious liability standard. Another criticism is the difficulty with intent-based offenses. While the theory is very effective for in cases of negligence, its application to crime requiring intent, willfulness, or dishonesty is problematic. Unlike knowledge, intent, or emotion, okay, knowledge, intent, and emotion cannot be easily aggregated. It's not possible. It can't be easily aggregated. To me, I even believe it's impossible. And then the third criticism is that it lacks conceptual precision. We move to the next theory, which is corporate fault theory. And all the foregoing three theories suffer from one limitation or the other. But the corporate criminal liability, okay, so all the foregoing theories suffer from limitations. They are optimistic rather than holistic. Corporate criminal liability is in all three a derivative form of liability. And this is because okay, so the limitation for the three theories that I've mentioned earlier is majorly because these limitations and from the desire to. Sir?
Okay.
What did you say, sir?
You didn't start by 5 on the dot. But I expect that by now we have finished talking about corporate liability. Please conclude.
Okay. I'll let my colleague conclude, sir.
Okay.
Mike, can you conclude?
Good evening, learned Prof. Sorry, Timmy, you touched on chapter 3.
No, I haven't touched on chapter 3.
Good evening, learned Prof and my colleagues. I quickly want to rush chapter 3 and then allow my colleague to wrap it up. First, chapter 3.
We have 2 more papers to take. I give you the next 10 minutes to round up.
Okay, learned Prof. So quickly, we talked about the legal framework and the judicial attitude. First and foremost, we looked at the fact that the issue as regards corporate liability in criminal law has to do with the elements that are required to establish any offense. Basically, the intention and then the act, that is Atus rules and the Misra, they are the basic element, and these elements are literally lacking in a corporate organization. We also mentioned the fact that sorry, sir.
Go on.
Okay, we also mentioned the fact that in Nigeria, basically, we do not have any substantive law on liability on corporate bodies. We refer to Section 89 of the Companies and Allied Matters Act, which provides, and I quote, any act of the member in general meeting, the board of directors, or of any managing director, while carrying on in the usual way the business of the company, shall be treated as the act of the company itself, and the company shall be criminally and civilly liable, therefore, for the same extent as if it were a natural person, provided that, so the law made provision on the condition that a company will be held liable. I then proceed. We mentioned the fact that the present law in Nigeria requires the invocation of the provision of the general criminal law so as to prove either the offense of manslaughter or the offense of homicide, which are the things required which are the offense relating to corporate liability. We refer to the case of Amma versus Oxford, where the Supreme Court made it clear that a company has no soul or body through which the act, it can only do so through human agent, but which act they cannot be personally held liable. So that is to say that the challenge in holding corporate bodies liable in criminal offense is the fact that they are neither human beings, so they do not have any soul and they do not have any mind, but act through human agents. Also, in the case of Odessa versus FRN and another, the court equally stated it strikes law that a company being a legal abstraction cannot on its own as an entity form the necessary intention, measure, and carry out the act, Atus rules, to constitute the commission of a crime. Criminal liability attaches to a company through the action of its officers. Director of Public Prosecution versus Kent and Suzette, the court also referred to that particular authority. As a former British colony, the Nigerian legal system was modeled after the English legal system. Hence, the common law position represents the law in Nigeria. Lord Denny, in explaining the intricacies / rationale for corporate criminal liability, memorably described the position in H.L. Burton Engineering Company Limited versus T.J. Graham and Son Limited. It stated, the learned law lord stated thus: a company may in many ways be linked to a human body. it has a brain and a nerve center which controls what it does. It also has hand which holds the toes and acts in accordance with direction from the center. Some of the people in the company are mere servants and agents who are nothing more than hand to do the work and cannot be said to represent the might of or will. Now, this particular authority, the learned law lord was referring to the managing minds of the company. That is the directors and maybe the staffs. The directors, for instance, are seen as the brain behind the company, the function of the company. Whatever instruction they dish out, the staffs of the company carry on to that. So to that extent, Lord Denny inferred that the company is indeed a human being. That is the essence of, that is the purport of that authority. On the question of which individual qualify as a controller for whose acts a company is criminally liable, the English House of Lords in Tesco Supermarkets Limited versus Nat Trust stated, a company may be criminally liable only for the act of the board of directors, the managing director, and perhaps other superior officers of a company who carry out the function of management and speak and act as the company, or of a person who is in actual control of the operation of a company or part of them and who is not responsible to another person in the company for the manner in which he discharge his duties in the sense of being under his order. So that is the explanation as to who is really in charge of a company. I would proceed to our comparison. There are some plethora of authority we have alluded to.
Don't proceed to any other thing. Conclude. We will read your paper.
Thank you, learned professor. So, to conclusion, so we concluded corporate criminal liability remains one of the most complex and evolving areas of modern criminal jurisprudence. It grapples with the challenges of attributing criminal responsibility to artificial legal entities that lack physical form and moral consciousness, but with eminence, economic and social power. The traditional model, vicarious liability, identification theory, and the modern recent aggregation or organizational theory, each of which we alluded to this theory, if looked into, would help to amplify the criminal liability of corporate bodies. Our recommendations, we recommended that codification of corporate criminal liability in the criminal and penal code. The Nigerian criminal code applicable in the south and penal code applicable in the north still largely reflect colonial era principles. So we are saying that there should be a shift reflecting to the developments around the globe to enable our criminal justice system to hold these companies accountable. And the second recommendation is that the adoption of a hybrid liability model. Nigeria should consider a hybrid approach that incorporates elements of identification, vicarious, and organizational fault theories. Our third recommendation, legislative emphasis on corporate compliance and due diligence. New corporate crimes legislation should intensify be enacted to ensure that they take care of recent development in the corporate world. Capacity building for prosecutors and regulatory bodies. Also, yeah, this is very germane because most of the companies are escaping like criminal liability based on a lack of knowledge or lack of competence in this area of law. We also stated that stronger sanction and alternative remedies should also be incorporated. We also mentioned that public education and advocacy should be geared towards educating people or maybe the prosecutors around this area. We also had a reference. Learned Prof, sir, we have concluded, and I appreciate the indulgence of Learned Prof and my colleagues.
Thank you very much. Let's have the second. We will discuss the three papers for the first 1 hour. next week before we look at area of concentration. Okay? So let's take the remaining two so that next week we just be for that.
All right, sir. Good evening, sir.
Motive and malice.
Yes, sir. Good evening, sir. Can you hear me, sir?
Yes, I can hear you.
Okay. Good evening, Prof. Good evening, class. So, I'll be starting the presentation for my group. My name is Zena Bakari, but however, I would like my colleagues to confirm their attendance. Ibukun Meji, please confirm you're here.
I'm present.
Victoria Pereze, please confirm. Victoria.
Victoria is not present.
Taiwo Oluwabukumi, please confirm.
She was in class shortly. Let me check what's going on.
She's currently on the call. I don't know. What about Bukumi? All right, I guess they'll confirm when they're here. Okay, so I'll be taking the introductory parts of our paper, basically part 1 and part 2, and I'll try to be brief with it. So our seminal paper is titled Motive and Malice in Thought, as Prof mentioned. And as we know, thoughts are civil wrongs recognized by law as grounds for the institution of an action. They give rise to liability when one person's wrongful conduct causes harm to another, and these wrongs can include battery, assault, defamation, and others. But looking beyond the act itself, it is important to examine the mental element, that's the mens rea, behind the act. That is the mindset or the purpose that guided the defendant's behavior. And this is where motive and malice comes in. And simply put, motive refers to the underlying reason or driving force behind a person's actions. It is why a person does something. For example, if I block my neighbor's access road, my motive could be to protect my property, or it could be out of spite. Like, I just want to be spiteful, right? But however, in tort law, motive is generally irrelevant. But what matters is whether the act itself is lawful or unlawful. So this principle was established, confirmed in Bradford Corporation and Pickles. Right. In this case, the defendant lawfully diverted underground water from his land, hereby depriving the local council of supply. So even though his motive was clearly to frustrate his neighbor because there was some dispute as to land, the House of Lords in that case held that he had a lawful right to do what he did, that motive could not make a lawful act unlawful. So in contrast, when we look at malice, it refers to wrongful or improper intention, an intention that is aimed at causing harm, acting with a deliberate purpose to cause injury, or injury motivated by ill will, hatred, or spite. Malice doesn't always mean anger or hatred. Rather, malice can be actual or implied. An actual malice refers to a deliberate intent to cause harm, while implied or legal malice arises when a person acts recklessly or without lawful justification. In this case, it differs malice from the conduct, the context, or nature of the act itself. For instance, publishing a false article knowing that it could ruin someone's reputation, that amounts to malice, because the intention, your conduct, the nature of the act shows that it will cause harm, it will ruin someone's reputation. So to give text to implied malice, in our paper, we looked at Nation Media's injury. It's a Kenyan defamation case. The High Court considered whether the media group actions could be termed as malice. So in this case, the media group published statements about the respondents, right? The respondents alleged involvement with a particular regime, and the court noted that malice does not necessarily mean spite or ill will. It's more of like recklessness or failure to verify facts can also constitute malice. And in this case, the court found that the language used in the publication, it is not proportionate to the fact itself. So it therefore led to the inference of malice. So that is an example of implied malice. So while a motive can be good or bad, which is often confused with malice, the key distinction here is that motive is usually about internal reasoning, which may or may not affect legal responsibility. Whereas malice, on the other hand, has direct legal consequences. So it is not about emotion. It is about the fact that someone did something wrongfully and he did this intentionally. Right. In summary, what I've been trying to say is that motive explains why a person acted, right? Why a person carried out some actions, but malice determines whether they did so wrongfully or intentionally. Right. So in our paper, we also looked at the role of motive in torts. So while motive is generally not decisive in tort law, it plays an important evidentiary role. That means it can be used to establish malice or to show that an act, though seemingly lawful, was done for a wrongful purpose. So we looked at the case of Guardian Newspaper Limited and Ajay. In this case, Court of Appeal held that where a statement is made with a dominant motive to injure, right, malice can be inferred, and defenses like qualified privilege will not apply. So in essence, what I'm trying to say is, while motive tells us why the defendant acted, malice tells us whether the act was wrongful. And in certain torts, right, motive becomes relevant in helping the court determine whether the defendant acted with malice. So this takes us to part 2 of our paper, where we examine how the concepts of motive and malice are interpreted and applied within the framework of Nigerian tort law. So in the Nigerian legal system, motive is usually irrelevant when determining tort liability. However, the courts have typically focused on the legality of the defendant's conduct rather than the personal reasons or emotions that may have inspired those actions. So if a person acts out of envy, spite, or greed, what we call a bad motive, they are not liable in tort unless their conduct was itself unlawful. Right. So, however, there are exceptions, right? The exceptions lie in intentional torts, such as defamation, injurious falsehood, and malicious prosecution. So, in this sense, the defendant's state of mind is not only relevant, but is often decisive. And motive becomes legally significant, but not on its own. It's just that it helps to determine the extent in which you can find malice, right? So this position is reflected in Nigeria's statutory and constitutional frameworks. For example, the 1999 Constitution in section 37 to 44, which make provisions for rights. So rights such as dignity of human person, freedom of expression, and the right to own property. So while these are fundamental rights, they also interact with tort principles. So when individuals, government officials, or private individuals, any individual at all, when they infringe on these rights with malicious intent or bad faith, the action may amount to a constitutional tort, and in such case, malice is what triggers liability. So similarly, under the Criminal Code, Section 24, it provides that a person is not criminally responsible for acts done accidentally or without intention, right? It is not the motive, but it's the presence of intent or malice that attracts liability. So even if an act is done out of selfishness or spite or anger, it remains lawful unless it breaches a legal duty or it infringes a right. So we also looked at other cases like Uko and Mbaba, Ntan Batokwe, Guardian Newspaper, and Ajay, like I mentioned earlier, and they all reaffirmed the position. Sir? Hello, sir.
Who is disturbing us? I'm not the one who.
Okay.
It's somebody who is having a conversation by the side.
All
Go
right,
on.
sir. Okay, so these cases reaffirms the position. They explained motive and what conduct are. They try to distinguish between them. So in summary, Nigerian tort law treats motive as a background, but malice as central, especially in torts where intention and bad faith are required to prove what constituted the malice, right? So I think that will be all from my end. So Victoria, please take part 3. Is Victoria here?
Okay, good evening, everyone. Please, can everyone hear me?
Yes, we can.
All right. Sorry, I was having a bad network earlier. That was why I couldn't respond. So I would be touching on part 3 of our paper, which basically deals with the intersection of motive and malice. This basically explores how motive, being the underlying reason for an action, and malice, being wrongful intent, interact in tort law. Now, while they are conceptually different in practice, courts often use evidence of motive to infer the presence of malice, especially in intentional torts, such as defamation, conspiracy, economic thoughts. Motive is often not legally required, but it influences judicial reasoning. I'm going to speak briefly on the evidential function of motive. Now, motive serves as an evidential tool to determine malice. This happens through direct statements or admission of hostility or ill will. It could also, another means by which motive could serve as an evidentiary tool is serving as a circumstantial evidence through patterns of behavior, the context of the action, timing, conduct that suggests intention to harm. In the application to tort law, there are different types of torts, as I've mentioned, that engage motive and malice differently. Courts apply different standards for intentional, economic, and reputational torts. We'll look at specific examples. One of such examples would be defamation law. The Reynolds revolution. In the case of Reynolds versus Times newspaper, 3 minutes, please. Right, so in the case of Reynolds versus Times newspaper, we have a publication that was made where the defendant was claiming that based on qualified privilege being the fact that the essence of making the post was because he had the responsibility to give the public the right information. It was not maliciously based. So in that case, Sunday Times published a story implying that the former Irish Prime Minister, Albert Reynolds, had misled the parliament. So Reynolds sued for defamation, and the newspaper publishing company argued qualified privilege under public interest journalism. The House of Lords created a test, which is known as the Reynolds test, to assess whether the publication was responsible and whether it was done with the interest of the public at heart. So the publisher's motive being just that he wanted to ensure that the public is carried along with vital political information was what was put to test. And also the extent to which the publisher verified the truth was central to whether the defense of privilege would stand. Another case relating to this would be the case of Jamel and Wall Street Journal Europe 2026, where it was the Reynolds rule was reaffirmed. Here we have WSJ, being Wall Street Journal Europe, publishing an article that alleged the Saudi claimant was under surveillance for terrorist funding, and then the claimant sued for defamation. The court, the publishing house, also in defense, evoked the Reynolds defense, and the House of Lords upheld the defense, noting that the publication was in public interest. As such, once again, the motive of the publisher was evaluated, and it was held to be legitimate. Another type of torts that engages motive and malice differently would be economic torts, which speaks to competition and malice. In that, under that aspect of economic torts, we have the cases of OBG Limited and Ll.M, Douglas and Hello Limited. For OBG Limited, here we see that the defendant took over a company believing he was lawfully appointed the court held that the belief in lawfulness negated malice because the belief was one that, to the best of his knowledge, was true. So this clarified that economic inference torts requires unlawful conduct, not just bad motive. We also have conspiracy, and yes, we have conspiracy. Under conspiracy, we have the case of Lonro Limited and Shell Petroleum Co. Limited. This case emphasized the need to analyze whether predominant purpose of multiple parties was to harm. Here, the court distinguished between legitimate competition and malicious collective action. The next thing we looked at in this chapter was jurisprudential perspectives. Now, this section explains how different schools of thought interpret the significance of motive and malice. The evolution of judicial approaches. Okay, so the evolution of judicial approaches.
Don't mind him. Maybe they work for last.
Oh my, come on. Hello, please. Am I still being heard?
I'm hearing you.
Yes, go on, go on.
Some disturbance from background.
The evolution of someone is really disturbing. The evolution of judicial approaches.
Please,
we are speaking
mute
about
your mic. Sorry, Ramon, please mute your mic.
Ramon, please, can you mute your mic? Ramon, mute your mic and put off your video, please.
Okay, so to the historical developments, which captures the evolution of judicial approaches, we commenced with the early common law developments that began under the early common law. Here, motive was considered irrelevant. This can be seen in the case of Bradford versus Pickles, the 1895 case of Bradford and Pickles. Here, motive was mostly considered irrelevant, but if the act was lawful, bad motive didn't make it unlawful. To provide where the act is lawful, it didn't matter if there was a bad motive behind carrying out the act. It would not be regarded as unlawful. In the mid-20s, which was the mid-20th century, the courts began to recognize the impact of malice in some cases. For example, the case of Hollywood, Silver, Fox Farm, and Emmett, where a landowner deliberately disrupted his neighbor's fox breeding. Now, in today's age and time, the modern era, courts now accept that bad motive plus lawful act can sometimes be tortious, even if the act was lawful, right? So bad motive plus lawful act can sometimes be tortious, especially in areas like defamation, conspiracy, and economic tort. We have a list of, we have a number of cases, that kind of postulate the judicial interpretations of motive and malice. We listed them within our paper. For want of time, I wouldn't want to start mentioning them one after the other. So I'll move to the theoretical perspectives on motive and malice. And the theoretical perspective on motive and malice brings together academic theory that supports or challenge how the court treats motive and malice. The first of such theories is the corrective justice theory. Here we have a scholar like Ernest Wainwright, Peter Benson, and here tort law is about rectifying wrongs, not just punishment. Under the corrective justice theory, tort law is about rectifying wrong. Malice also aggravates the wrong, so motive can justify higher damages or more serious findings. The next theory is economic analysis and deterrence theory. Here, we are saying that the economic analysis and deterrence theory is saying that law should minimize harm effectively. Motive, on the other hand, matters only when it improves deterrence. For example, preventing repeated harmful behavior. The next theoretical approach is the rights-based and dignitarian approach. Here it is based on Kantian ethics, and it emphasizes human dignity. So even if a person's act is lawful, if it disrespects another person's autonomy, it can violate rights. Another theory is the critical legal theory, which also has a lot of about 3 theories under it. That's the feminist jurisprudence, critical race theory, intersectionality. The critical legal theory for feminist jurisprudence, we have an argument here saying that traditional tort law ignores structural inequalities. Malice and motive is expected to reflect power dynamics, not just individual blame. And this is mostly tailored to sexual harassment cases. Critical race theory, on the other hand, focuses on how courts interpret motive in racially biased conduct. Here, traditional torts don't account for systemic harms. Finally, intersectionality combines gender, race, and class, which are basically the which we had feminist and critical role, handle each of them specifically. But here, intersectionality combines all of these together, and it suggests that courts must account for multiple identities that shape how harm is experienced by various persons. Because, for instance, harm is experienced differently for Black persons, and harm is experienced differently for women, especially when it comes to sexual harassment cases. So legal text for malice and motive should be context sensitive, to be tailored towards the extent to which different classes, different gender and race experience harm. That's about it for chapter 3. I'll be handing over to the final person to talk about chapter 4. Thank you.
Good evening, Prof. Good evening. I hope you can hear me.
We can.
Okay, sir. So I'll move forward to the comparative analysis. I'll start with Nigeria, and my colleagues have covered most of that, but I'll just like do a brief summary. So, in Nigerian tort law, which is deeply rooted in the English common law, due to its colonial heritage, it generally considers the motive irrelevant of determining tortious liability, except in specific torts where malice is a critical element. And this approach actually aligns with the principle established in Bradford Corporation versus Pickles UK, which holds that a lawful act does not become unlawful merely due to a malicious motive. And in Nigerian jurisprudence, malice is understood in 2 forms. That's malice in law, that is an intentional wrongful act without just cause, and malice in fact, which is the actual ill will or improper motive. And the legal system prioritizes the act itself over the defendant's state of mind, reflecting a corrective justice approach that focuses on remedying harm caused by the wrongful conduct rather than punishing the intent behind it. So thoughts such as defamation, malicious prosecution, and malice play a significant role, not only in establishing liability but also in deterring the egregious behavior by aggravating damages. And it also the focus ensures accountability, particularly when legal processes are abused with harmful intent. And Nigerian Constitution 1999 as amended and statutes like Criminal Code Act reinforce this framework. So I will move to the application in specific thoughts like defamation, my malicious prosecution, and under defamation, we talked about that the fact in Nigerian tort law, the malice is pivotal in defamation cases, particularly when a defendant invokes a defense of qualified privilege, and this defense protects the statement made in good faith or on privileged occasions. For example, a public interest report, and but it fails if the plaintiff proves express malice defined as a dominant improper motive to harm a plaintiff's reputation. So in the case of Sketch Publishing Co. Limited versus Ajagbe Mokeferi, the Supreme Court.
Yes.
Okay, sir. Thank you, sir. The
Uh,
Supreme Court of Nigeria ruled that a publication actuated the malice and actuated the malice by the malice negates privilege, qualified privilege, rendering the defendant liable. And also, as seen in the case of Ezenwa versus Ikeke, where the courts also defined malice as an improper motive, undermining the honest belief in statement's necessity. So I'll also move to malicious prosecution, where the thought requires proof of both an improper motive malice, so improper motive, and a lack of reasonable and probable cause. In Balak, I would look at the case of Balak Glass Emporium versus United India Insurance Co. Limited, where the evidence of ill will between the parties led to the finding of malice when the defendant intentionally caused water damage, demonstrating how motive influences liability. And also in UBA versus Ozuemena, it recognized the lawful act, that's
Abi.
filing a. Please, can you still hear me?
yes, we can hear you.
Right. Like filing a lawsuit, and it can become tortious if driven by an improper purpose, such as harassment or highlighting the role of malice in transforming otherwise permissible conduct into the basis for liability. I also look at trespass, where we talk about the fact that motive is generally irrelevant in trespass cases, as liability depends solely on the act of interference itself. As in the case of Bradford Corporation versus Picos Principle, which is influential in Nigeria, holds that a lawful act, that is, for example, excavating one's land, remains non-actionable despite malicious intent. However, when the trespass involves intentional harm, malice can aggravate damages, like in case of Amodu versus Amode. The court noted that deliberate and malicious invasion of land, even if technically lawful, could warrant higher damages, emphasizing the deterrence and compensation for such conduct. So I would move to South Africa. South Africa tort law is referred to as the law of delicts, and it is basically grounded in the Roman Dutch legal tradition, distinguishing it from the common law systems like Nigeria and the United Kingdom. It places significant emphasis on animus innuendo, that's the intent to injure, making motive and malice central to liability in delicts involving intentional harm, such as injuria, that's injury to dignity or reputation. Unlike now, South Africa, unlike Nigerian laws, act focus, like they have their act focused approach. They have the act focused approach, and it integrates the defendant's state of mind, reflecting a moralistic tradition that assesses culpability based on intent. And this aligns with corrective justice by restoring the victim's dignity, and deterrence by penalizing intentional wrongdoing, sorry. And the South African Constitution of 1996 reinforces these true protections of dignity, that's in Section 10, and also freedom of expression in Section 16, shaping their delictual liability. So no comprehensive tort statutes exist, but common law principles supplemented by constitutional values govern the delict law. And I'll move to the application in specific torts for South Africa. I'll look at the inuria, that's the delicts, which it requires proof of animus inuriandi, encompassing malice or intent to injure. Like in the case of Lee Rooks versus the Supreme Court of Appeal found that the schoolboy's defamatory caricature of the teacher was malicious due to evident intent to humiliate, underscoring the motive's centrality in establishing liability. And this the focus of on intent distinguishing South African law from Nigeria and UK, where the act itself most times takes precedence. And I'll move to defamation. And it says that malice can defeat defenses like fair comment or public interest. In Media 24 Limited versus Duplessis, the court held that reckless disregard for the truth constituted malice, negating privilege. And this approach balances freedom of expression with reputation protection, similar to Nigeria, but with a stronger emphasis on intent itself. And I'll move to the UK, United Kingdom. And the UK tort law actually is also rooted in common law, and it's adheres to the principle that motive is irrelevant unless the act itself is unlawful, as established in case of Bradford Corporation versus Pickles, as I mentioned earlier. The A lawful act does not become tortious due to bad motive, but malice is significant in specific thoughts. So the UK approach also balances corrective justice, like remedying harm, with deterrence, that's punishing intentional wrongdoing, with recent statutory reforms like Defamation Act of 2013, which refined the malice rule to protect public interest like free speech. And now move to the application in specific thoughts like defamation, and it says that information is crucial in defeating defenses like qualified privileges or honest opinion. Like in the case of Orox versus Lowy, the House of Lords here held that malice requires proof of improper motive or reckless disregard for truth, ensuring only the egregious conduct that negates privilege. And the Defamation Act of 2013, Section 3, codifies the honest opinion defense, requiring malice to defeat it, emphasizing the balance between free speech and reputation protection. And also malicious prosecution. Malice is a core element requiring improper motive and lack of reasonable cause, as confirmed in the case of Willers versus Joyce. And this reflects deterrence by punishing abuse of legal processes. And I also talk about we also talk about negligence and nuisance on under this application of specific thoughts. Says that motive is um, irrelevant with liability based on objective standards of care, as seen in the case of Donogo versus Stevenson. And in nuisance, however, the malice can aggravate damages if it transforms reasonable conduct into tortious behavior. So I would say that across these three jurisdictions, the defamation consistently recognizes malice as defeating defenses like privileges. But South Africa's focus on the animus ignorandi makes it more likely to find liability based on motive, and it reflects the Roman Dutch roots. And in negligence, motive is largely irrelevant, though malice can aggravate the damages in Nigeria and South Africa. And trespass in the UK and Nigerian law focuses on the act itself, while South African the INERA requires intent, and it also highlights a moralistic approach. So Nigeria's act focus framework actually prioritizes the corrective justice. South Africa integrates the moral culpability, and UK balances both together. So with statutory reforms refining malice rules to protect the public interest like free speech. I would hand over to my colleague to round up for us. Thank you, sir. Thank you, everyone.
Good evening, Prof. Good evening, everyone. So in conclusion, our paper has provided a comprehensive analysis of motive and malice in tort law. It focuses on Nigeria, South Africa, and UK jurisprudence. The study has pointed out the challenges of these ideas and their application in various torts. The findings of our research demonstrates that motive and malice plays significant roles in determining liability in tort law. The general rule is that motive or malice are not relevant for tortious liability. However, motive and malice is relevant for a successful claim in the following torts: malicious prosecution, conspiracy, nuisance, and defamation. In negligence, motive is largely irrelevant across jurisdictions, though malice can aggravate damages in Nigeria and in South Africa. Trespass in Nigeria and in the UK focuses on the act, while South Africa in area requires proof of intent. Nigeria's approach is act-focused, prioritizing corrective justice to remedy harm. The differences between motive and malice is crucial. Motive is the ultimate object with which an act is done, while intention is the immediate purpose. When an act is done with bad intention, it is called malice. Malice, in fact, refers to performance of an act which may be legal, but with ill will or hatred or bad intention. The intersection of these concepts can have significant implications for legal outcomes. We also gave recommendations to Nigeria. The first one is to provide clear and distinction between motive and malice. Lawmakers and scholars strive to clearly distinguish between motive and malice and understand their respective roles in tort law. There should be consistency in application. Courts and lawmakers should aim in consistently applying the concept of motive and malice in tort law to promote fairness. Jurisdictional harmonization is another recommendation we give. Governments and lawmakers from different countries should come together to harmonize the approaches to motive and malice across jurisdictions so as to facilitate consistency and clarity. We also added that there should be additional research which is needed to explore the implications of motive and malice in specific thought and to examine the theoretical perspective on this concept. Then there should be legal education. Schools and training programs should emphasize the importance of understanding motive and malice in tort law and provide students with practical examples and case studies. Governments, legal practitioners, scholars, and lawmakers are encouraged to implement these recommendations, as this would help to work towards a more comprehensive understanding of motive and malice in tort law, and most importantly, to promote justice and fairness in the jurisdiction. That is the end of our paper.
Thank you very much. You have explored the twin concept of motive and malice. I don't know whether I did not get confused with your presentation. I used to think that malice is just a bad motive, and that malice is irrelevant if the conduct that has been actuated by malice is a lawful conduct. On the other hand, good motive is not also a defense. For example, if an adjoining property has a bunker, that is where you can hide when armed robbers invade the community, that does not make the property to cease to be a personally owned property, and will not stop the landowner from suing you for trespass if without his consent, but with the intention to seek refuge within his bunker or bunkers in his compound. You move into the compound or you enter the compound without permission. That will not, for example, stop him from suing you for trespass. Your motive, from the perspective of humanity, is not going to be a bad motive, but it's not going to be a defense for trespass. So we have seen the cases of Bradford Corporation and Pickles being hammered on, and that remains the position that your malice, that is your bad motive, your not too altruistic intention cannot of itself amount to a wrong in the law of tort if your conduct is right. Yes, we have seen examples of the treatment of malice in defamation and malicious prosecution cases. Malice is in itself an element of malicious prosecution, because the position of the law is that in the interest of the public, a person should not be charged to court for reporting to police or any prosecuting authority. So for that reason, no matter how stupid his suspicion was, nobody will hold him liable for anything for reporting what is suspected to the police. But malice now makes it a crime. If he had other bad motives in reporting, okay, like maybe he has a personal relationship with the person, most typically in land disputes, and he just wants the person to be kept away so that he can do whatever he likes with the land while the person is away, or he has a wrong political motive and all of that, which makes the prosecution, the reportage not to be with a good intention. So in that wise, the bad motive that he has would constitute the otherwise legal act of reporting to a prosecuting authority illegal. Okay? So basically, good motive is not a defense. And bad motives as a general rule is does not find a thought. Okay? But it is those exceptions that our presenters have hammered on. And even when they did a comparison between our legal system and the other legal system, we can see that we have virtually virtually all legal systems follow the same approach. So in a jurisprudence class, what do we want to know? That if a conduct is on its own right, the bad motive for putting it up may not be relevant, may not change it from being right to being wrong. Okay? And if a conduct is on its own wrong, the good motive for putting up the conduct may not turn it otherwise. Okay? So with those two general statements made, the theme of a discussion on motive and malice will be, what are the exceptions? When is it that your bad motive, okay, would on its own make your otherwise valid act illegal? And when is it, if any, that your good motive will constitute a defense? So we'll go over their papers again. I don't think we have any time to discuss more closely. We'll go over their paper again. let the presenters of the two papers so far for today give us a small bibliography of what to read, because I'm not sure that we will not answer questions in especially in corporate liability. I'm not sure that we will know, although I'm not too sure yet. By the time I come next week, anything that we will examine, I will tell you about them. But what all of you should do for me now is papers that have been presented and the class had uploaded, just give us a summary of your bibliography so that people can go and read them, especially if by next week I point to the topics covered by those seminar presentations as being important for the exam. So the last one now, is there any difference between civil law and criminal law when you are talking about motive and malice? Can we have the presentation in the next 20 minutes? I leave your class by 7 on the dot.
Hello, sir. Good evening, sir. Good evening, everyone. So our topic is motive, and I'll be presenting with Emmanuel Adewole and Ajoke Onilude. So I'll begin now.
Okay, yeah. Go on.
Yes. Okay, sir. Our paper examines the concept of motive and malice within criminal law. Sorry, you can't hear me?
We can hear the last sentence. You can't hear me. Well, everything you said before then, we couldn't hear.
Okay, sorry. I said our topic is motive and malice in criminal.
Seminar.
Can I go on?
Go on now. When you ask this question, they are clear. But when you start talking, we don't hear you again.
Okay, sir. So our paper examines the concept of motive and malice within criminal law, contrasting them with intent and mesra. Motive, often regarded as the rationale behind an act, is typically excluded from determinations of criminal liability. So criminal law is not solely about punishing actions. It also considers the mental state of the accused. Our topic, motive and malice in criminal law, forms a critical part of understanding mental elements in criminal responsibility, particularly how the reason behind a criminal act and the quality of the intent influence legal outcomes. At first glance, motive and malice might appear similar. They both concern the mind of the offender, but in legal terms, their roles are quite distinct. This presentation unpacks their doctrinal distinctions, jurisprudential relevance, and applications across jurisdictions, especially in Nigeria. The two key concepts in this regard are motive and malice. Motive, the underlying reason or purpose behind a criminal act, while malice, the legal term for a wrongful or blameworthy state of mind, especially in serious crimes like murder. While both deal with the mind, they play different roles in legal analysis. The purpose is to distinguish clearly between motive and malice, assess their legal significance, and examine their implications through philosophical insights, statutory interpretations, and case law, particularly within Nigerian context. Motive is the emotional or psychological reason for committing an act. It explains why a person acted, but it does not determine criminal responsibility. Motive is generally irrelevant to establishing criminal liability. It may be morally significant, but as legal principle, it is not an element of most criminal offenses. Criminal law is more interested in mens rea and actus reus, not why the person chose to act. Example is if a person kills their terminally ill partner to end their suffering, that's good motive. Despite this, they may still be convicted of murder if the intent to kill is present. Malice, on the other hand, is a mental element denoting a deliberate intention to commit a wrongful act or recklessness as its consequences. The role in criminal law, it is central to proving offenses like murder. Unlike motive, malice is a legal requirement for liability in many serious crimes and can either be expressed or implied. So now we have two types of malice, which is express and implied. Express malice is where the defendant had a clear, deliberate intention to kill or cause grievous bodily harm, while implied malice is inferred from the defendant's conduct, such as use of a deadly weapon, brutality or cruelty, actions showing reckless disregard for life. The criminal code, especially section 24, emphasizes voluntariness, intent, foresight, and the role of accidents. Malice is inferred based on the circumstances of the act, not necessarily the defendant's motive. Particularly, we can see in Okoro against the state. The Supreme Court held that the deliberate use of a knife on the chest was sufficient to establish malice afterthought. When a person intentionally targets vital organs with lethal weapons, the court may infer intent to kill or cause grievous harm. We also cited Eze against the state, Gira against the state, Mbang against the state. We also touched the jurisprudential perspectives and motive in sentencing and policy. So my colleague will take over from here. Thank you, sir. Manuel, you can proceed now.
Okay. Now looking at motive. Motive is the reason, a desire prompting conduct. A desire transformed into a practical incentive or stimulant to action. It is the reason by which a defendant does what they do, looking beyond the act to its consequences and the desire to bring them about. Motive as an essential element of a crime is never presumed as a matter of law, but must be proven as a matter of fact, including the accused's mental capacity to entertain it and its actual formation and concurrence with the physical act. Now, intent, which is distinct from motive, refers to the specific mental state required by a crime's definition, typically the intention to perform the forbidden act or bring about the external elements of the offense, that is the conduct, circumstances, and the results. These mental states are commonly referred to as mens rea. While motive and intent refer to mental states, intent is central to criminal liability, whereas motive has generally been deemed irrelevant. The conventional wisdom in criminal law states that motive is irrelevant to criminal liability. A bad motive does not establish liability, and a good motive standing alone is not a defense to most crimes. Criminal liability is primarily concerned with a defendant's intentions and not their reasons for acting. The law prohibits acts, not bad motives, and good motives do not exonerate crime. The primary principle is that a person is liable if they commit the actus reus with the required mens rea, regardless of the reason for acting. Committing a legally prohibited act, even with a good motive, can still lead to criminal liability if the required intent is present. Now, there are certain exceptions where motive can be regarded as relevant. For instance, in crimes of ulterior motive, some offenses explicitly require a further intent, which may sometimes be referred to as motive as an element of that crime. For instance, burglary. That is when you break into a house. Obviously, you are breaking into a house for another reason other than just breaking in. You might want to steal or commit other crimes. There are also aggravated crimes. Motive can be an element that increases the seriousness of an offense, such as in hate crimes, where the hatred is based on a victim's characteristics as a factor. Now, motive can also be relevant in case of defenses for offenses. That is the justification and excuses that a defendant relies on for a purpose for acting and providing a basis for a defense to liability. Then now there are reasons for the legal distinction between motive and intent. The law distinguishes motive and intent for several reasons. One of them is the focus on legally defined wrongdoing and culpability. Criminal law penalizes individuals for specific harms and assesses their culpability primarily based on their legally defined mental states. That is intent, recklessness, knowledge in relation to the prohibited conduct. It focuses on the badness of the action and the intent accompanying it rather than the complex hidden motives. Another reason is the rule of law, certainty and fair warning. Clear definitions of offenses provide certainty, allowing individuals to know what conduct is criminal. Relying on subjective motives like wickedness or moral guilt lacks stable basis for legal definitions, while specific mental states provide greater clarity. Motive as a grounds for defense or mitigation. The law accommodates moral significance of motives by allowing certain motives or states of mind to serve as basis for defenses, e.g. duress, when someone is forced to carry out an action against his own will. For instance, someone is held at gunpoint to impute a password for a company's specific secret information. Now, there's also capacity for intentional action. Criminal law presumes individuals are rational and capable of understanding choices and controlling their conduct. Intent is linked to this capacity, making individuals responsible for specific intents formed, regardless of their underlying motivations. Now, we look at the philosophical perspectives on motives. Jeremy Bentham argued that no motive in itself is either good or bad, but must be evaluated purely by its tendency to produce pleasure or pain. While intention is central to liability, motive influences the degree of moral blameworthiness and future risks. Motive is crucial for determining appropriate punishment and preventive justice. John Austin maintained that legal obligation arises from a sovereign's command, largely marginalizing motive's role in criminal law. He recognized intent as immediate objects of the act and motive as the spring producing it. Though not essential for legal guilt, motive could influence sentencing and moral appraisal. H.L.A. Hart distinguished between justifications related to the act and excuses related to the actor, generally situating motive with excuses related to the actor. Hart argued that motive can affect the fairness of assigning criminal responsibility and supports a system that respects moral intuitions about blame and proportionality. Malicious motives may justly attract greater punishment, aligning with legal rules with moral responsibility and ensuring fair labeling. Now, motive plays roles in sentencing and punishment. In sentencing, motive and surrounding circumstances are routinely and explicitly considered to reflect individual culpability, character, and pressures faced. Partial defenses that reduce murder to manslaughter and allow judges the discretion to impose sentences reflecting varying degrees of culpability are often linked to motive-like states of mind. Factors like provocation brought about by prolonged stress or act of mercy in the case of assisted suicide. Now, in policy, discretion exercised by officials like prosecutors significantly allows motive to impact outcomes. For instance, in assisting suicide cases, a compassionate motive tends against the prosecution, while professional or commercial motives may favor the prosecution. This discretionary filtering relies on factors like low culpability and sympathetic motivation. I'll let my colleague take over from here. Thank you.
To conclude, Let your colleague conclude, please. I have 5 more minutes.
Good evening, sir.
Go on.
Yes, sir. So I would be looking at the Nigerian case law and analysis on malice in criminal law. Like my colleague earlier said, we looked at the case of Okoro and the state. This case remains a cornerstone of the Nigerian jurisprudence on express malice. The Supreme Court held that the deliberate use of a deadly weapon, in this case, a knife on a vital part of the body, such as the chest or head, was sufficient to establish a malice afterthought. The case emphasized that when a person intentionally targets vital organs with a lethal weapon, the court may safely infer that the accused intended to kill or cause grievous bodily harm. Such conduct satisfies the requirement of mens rea for murder, even if the accused denies intending death. This judgment aligns with the express malice doctrine, where the intent to kill or seriously harm or cause seriously harm is evident from the facts of the case. We also looked at the case of Jira and the state. In Jira, the Supreme Court reaffirmed the intent to cause grievous bodily harm is enough to sustain a murder conviction, even if the death was not specifically intended. The accused inflicted serious injuries during a fight that led to the victim's death. The court held that malice afterthought may be inferred from the natural consequences of the act as death or serious harm. This reflects the principle
But do you think that in Nigeria, really, that those cases that tend to emphasize the nature of the instrument used to kill and the part of the body of the victim that is of the disease that is directed at. Do you think that they prove anything relating to malice, given that that in itself is an element of intention under, is it section 316 or 317 of the criminal code? Because the clear provision of the code itself is that if you also intend to cause bodily harm, to cause serious bodily harm, that is enough to convict you of murder.
Yes, sir, but it's
what
just
I'm trying to say is that, but for section 316.
Yes, sir. Section 316 provides for the actions that might lead to the death intentionally of an individual. Yes, so we are just looking at the implied malice in criminal law.
Okay.
So ordinarily, but the fact that it led to death, or it doesn't matter whether it was a reasonable, the harm done was reasonable or not, as long as it can be proved that this action causes death, then that will be enough ground to convict the defendant. So we also looked at other cases of Eze and the state, Mambang and the state. So I would go forward to the comparative case law analysis on.
When are you going to do that? Not today. It's already 7. Conclude. We will read your paper. We will read your paper. Let everybody read the papers of today again, so that we will talk about them. Give some 30 minutes to talk about them before talking about what to prepare for an exam. Conclude, please.
Yes, sir. In conclusion, it's a settled principle of law that you do not punish someone for an act or an omission that he is blameless. This is expressed in the maxim, no liability without fault. The doctrine of mens rea is to the effect that there is no liability without fault. This becomes the second arm of an offense. The mental element of an offense, however, the scope and nature of this doctrine is not precise, or at best confusing to judges, like my earlier colleague has said, when he looked at the theories of HLA Act and that of Austin. At times, the jurist may interpret a particular case as even dispensing with the requirement of mental elements, which is known as a guilty mind. This is what is seen in the strict liability offenses. In some cases, vicarious liability offenses. It was a common understanding that the provision of Section 24 of the Criminal Code, which is similar to the Queen's Section 23 of the Queen's Land Criminal Code, that's applicable in Austria, as dispensed with the recourse to the common law doctrine of mens rea. However, like one scholar, which we've quoted earlier, observed that the non-continued application of the course of action in tort, that though the course of action which we have buried, that's the principle of mens rea, which has been buried in Nigeria because we've codified it into Section 24 of our criminal code, still rules us from the grave. So it means that mens rea is still in a way applicable in the court, and the court still enforces this principle. So we recommended that the Belgian Penal Code the Belgian Penal Code should be incorporated in a duty to rescue persons who are exposed to serious danger. This is just further providing that the Good Samaritan's law in Nigeria should be incorporated, or the Good Samaritan law should be incorporated in Nigeria. We also respectfully submitted that there is no need to reevaluate this area of law. Some jurisdictions have made it culpable omission not to aid the person exposed to grave physical harm, where such assistance can be rendered without danger or peril to the aider. We also looked at that there's need to expand the scope of criminal liability to include offenses committed by artificial intelligence, robots, especially with the recent development of the society in science and technology. There's also need for specific legislative opinion or intention as to the criminal liabilities of persons with genetical hereditary disorders. Thank you very much, sir.
You're welcome. On this note, I'm leaving the class for today. So we will discuss the papers of today for the first 30 minutes next week. Hopefully before next week lecture, I would have settled for the topics we should examine. I don't think it's fair for me to leave you blank, given that we went through so many unrelated topics. Okay, as a general rule, I have a way of dividing the semester's paper into 3 groups and ensuring that I cover each of the 3 groups so that there is at least one question from each group. Some group may have more than one. The first part, for which we spent close to half of the semester, is at the possession, ownership, property parts. Then we move to the theories of theories. And we can group contract and thought together for that. Then we move to criminal and civil liability and issues arising therefrom and all of that. So those are the 3 major groups. And we see what part of the presentations we are going to look at for purpose of exams. And talk generally next week. See you next week.
Sir, please, are you giving us materials like last semester?
Thank you, Prof.
Thank you, sir.
Thank you, Prof.
Thank you.
Welcome.
Thank you, Prof. See you next week.
Thank you, sir.
You didn't
God bless you,
allow
sir.
us
Thank you,
as
Prof.
giving us materials. Thank
No,
you.
now he said next
Let's
week.
class now.
Which
Next week
material
we have
again?
For
class.
AOC, I'm
We have
saying material,
presentations.
not AOC.
If I need to give you any material, we'll talk about that next week.
Yes,
Which
sir. Thank
material
you, sir.
again? You have all these topics, these papers. You are still asked for material.
Okay, so the prof has told you that all the papers are 100% okay to read for exam.
If
When
they
you
are
get
not
your area
okay
to
to read
concentrate
for
now.
any, if they are not okay to read for any paper, I will tell you.
Thank you, Prof.
Yeah.
Thank you,
Thank you,
Prof.
sir.
Thank you,
Yeah,
sir.
thank you, sir. Thank you, sir. Yeah.
We appreciate you.
Thank you, sir. We are grateful.